what is this concept of independence? How do we control the conflicts of interest on boards of directors?
Of course, there is a rule now that is provided through both the New York Stock Exchange and NASDAQ that the majority of a board needs to be comprised of independent directors. And in fact, the major standing committees of the public corporations, the audit, governance, and compensation committees also need to be independent. So we have this sense of what that these directors need to be independent. What does independent mean? Well, for purposes of the exchanges, independence means that there's no material relationship that the individual director has with the company. The individual can't be an employee, of course, of the corporation or have any significant services agreement or consultancy arrangement. So that's the basic requirements for independence. And the board is obligated to make an affirmative determination of that independence. But in fact, what's happened, many public companies have their own standards that they publish that supplement the standards that the New York Stock Exchange or NASDAQ use in determining independence. In adopting these independence requirements, the New York Stock Exchange made very clear in their commentary to those rules that the concept of independence goes well beyond the financial entanglements, as you were suggesting, Kirk. The New York Stock Exchange intends that this concept of independence be very broadly interpreted. And I think that is important, trying to understand the status of directors as independent directors.
Why have the exchanges made this requirement for a certain percentage or a majority independent directors, and why is that important to the functioning of the company?
Well, this all comes out of Sarbanes-Oxley. And Sarbanes-Oxley, as we remember now, grew out of a series of corporate disasters where many of the critics and commentators who evaluated the events of the late 1990s and early 2000s felt that the cronyism on boards was responsible for a lot of the laxity in corporate governance. Now, you have known a lot of corporate counsels, and you've worked yourself in two of the very largest companies here. Does having independent directors make a difference to the process of the board's work? I think it's very important. I think it's very important. But I also think, and this perhaps gets lost sometimes, that it's important that a majority be independent, but not all. Because I think interested directors, those directors who have some relationship with the company, particular prior work experience with the company, and are well informed about the company's business and the industry in which the company participates, are some of the most productive and valuable members of a board. How does this concept of independence of board members relate to their fiduciary duty to the shareholders, presumably? Sure. Well, certainly a board member is governed by state corporate law, and almost all states require that a board member in their fiduciary duties comply with the duty of care and the duty of loyalty. Now, it's the duty of loyalty, I think, that's most implicated here. And the duty of loyalty is that the director must act in good faith in the interest of the corporation of which they're a director and its shareholders. So that's the standard. Now, of course, the director has a great deal of latitude in applying that duty to the decisions that they make, and they're protected in large part by the business judgment rule, which gives wide latitude for the director to exercise good judgment, and as long as they're acting in good faith, and again, in the interests of the corporation. But now, where there is a conflict, where there is some interest that a director might have, for example, in the underlying transaction, suddenly the business judgment rule may not apply. And it's important that directors need to understand that they are risking really their very adherence to their duty of loyalty if they don't take appropriate steps to identify the conflict that might arise if they have some interest in the transaction that's being discussed. So if a board is making a decision on a particular merger or buyout or something like that, then it's their independence in general and their independence regarding that particular transaction. Correct. I mean, there are really two issues. One is their disinterestedness, but then also that they in fact are truly independent and able to express a view about the transaction. And independence means that they're, for example, not an agent of someone else, they're not beholden to another director who's supporting the deal, but they are truly independent of mind and not under anyone's influence. So that we have independence and disinterestedness, which must be, important components of a board member's decision to participate in that vote.
Thank you for laying the groundwork here. You have a number of very interesting views.